Assalamualaikum warahmatullahi wabarakatuh. Saya minta yang dekat belakang penuhkan yang dekat depan. So tak adalah nampak kosong sangat dekat tengah-tengah. Before your name being called. Assalamualaikum warahmatullahi wabarakatuh. Yang berbahagia, Ketua Pegawai Korporat dan Strategi, Pejabat Strategi Pertumbuhan Kumpulan iaitu Tuan Haji Idris bin Ishak dan Pengurus Besar Kanan Perkhidmatan Korporat Puan Sapna binti Tumidi, Ahli-ahli pengurusan PKNS, Ketua-Ketua Eksekutif Anak Syarikat PKNS, Ketua-Ketua Bahagian Pegawai-Pegawai Kanan serta hadirin yang dihormati. Majlis pada pagi ini mengalu-alukan kehadiran Puan Putri Noor Shariza binti Noordin dan Puan Lai Wai Fong iaitu Peguam dan juga Rakan Kongsi daripada Tetuan Shearn Delamore selaku penceramah jemputan kita pada pagi hari ini. Alhamdulillah, Bahagian Perundangan dengan kerjasama Bahagian Sumber Manusia berpeluang untuk menganjurkan Klinik Perundangan Siri ketiga dan juga yang terakhir untuk tahun 2023 dengan tajuk Key Points in Negotiations of Joint Venture and Privatization Scheme. Untuk makluman tuan-tuan dan puan-puan, program pagi ini kita akan bercakap pada dua sesi. Sesi pertama, kita mulakan dengan pembentangan daripada Puan Shariza, which Puan Shariza akan bentangkan on the theoretical part on the privatizations and juga joint venture. And then on the second part, it will be by Puan Wai Fong, which is Puan Wai Fong will cover on issue dispute resolutions and juga litigation issues yang arrive from JV and privatization. Okey, tanpa melengahkan masa, saya menjemput Puan Shariza untuk memulakan pembentangannya. Dengan segala hormatnya dipersilakan.
Assalamualaikum semua, selamat pagi, salam sejahtera. Terima kasih kepada Puan Sabna, Tuan Haji Idris, Puan Sheila dan juga pihak PKNS mengundang kami untuk memberi klinik perundangan ni ya. So masa kita taklah panjang, masa kita singkat. So saya akan cuba tumpukan kepada isu-isu yang penting ya. Key salient points, key salient issues di mana kami dalam pengalaman kami dah tengok ada menimbulkan masalah JV. So kalau ada apa-apa soalan berkenaan dengan particular issue, particular matter, akhir nanti kita orang boleh adakan session Q&A and we will try and answer your questions and address your issues. So tanpa mengelengahkan lagi, So, sesi saya akan saya bentangkan mengenai joint venture dahulu, isu-isu joint venture in the shareholders agreement, joint venture agreement. Kemudian saya akan ke privatization agreement. So, I think I will be saying this, I'll be doing this in English because most of your agreements that we have seen, your joint venture agreements, your shareholders agreement, your contractual and commercial agreements are mostly in English anyway. So the first thing I think that parties or PKNS, pihak PKNS would have addressed your minds to when you're going into a JV is the goodwill and cooperation with your JV partners. And I think that's the first thing both parties need to bear in mind. It's not really competition, it's actually cooperation for the benefit of a win-win situation for both parties. So, but in our experience, what we have seen in some of the JV agreements with other clients, also some with PKNS or anak-anak syarikat PKNS, is the identity of your JV partner. The due diligence on the JV partner, what is the obligation and what's the benefit you want them to give to you, enough knowledge. Make sure you engage with third parties to do background check. The unfortunate experience we had once with one of the anak syarikat PKNS is dah masuk JV agreement, dah sign JV agreement, then the PKNS realised, or sorry, the anak syarikat realised that that party is not who they said they were. Because in some jurisdiction where not common law jurisdiction like England, UK, US semua, it's a bit more structured how they incorporate companies similar to Malaysian law. But for some jurisdiction like African states, China, they are able to use names of another company to create a new company. So kalau kita buat Google search aja, we will think it's actually what's on the website. But actually you need to go down to the ground to actually do a background check, do company search. So what we do is we engage with our legal counsel in all the jurisdictions to do that background check. You need to do financial check and you need to do background check. Secondly, a lot of parties create special purpose vehicle untuk joint venture, right? So that special purpose vehicle normally is only a $2 company or a RM2 company. There's no asset, there's no capital. So that's the financial backing or financial strength. You can enter into the company, parties can say, yes, we are creating SPV just because we want to have it only specifically for this JV. Boleh, that's okay, that's quite common. But you must ensure that that party has put enough capital in that company. And what is the asset? Because if there's enforceability issues, kalau ada breach, you are enforcing against a RM2 company. No point. It's only a paper judgment that you can get. So, what we experience when we deal, katakan we are on the Malaysian side and we deal with, say, US council or any other countries, when our clients want to set up just an SPV, the other party always insists on giving a good standing and financial sort of report on the company. So it's common that JV parties can ask the other party, can you give me proof of your financial situation? So you look at the financial records, the technical expertise. What you have to look at is not just them having the technical expertise, where are they getting that technical expertise from? Is it in-house? Or is it something they get from a third party? Because if it's from third party, the IP rights, the intellectual property rights, may not be with them to give it to you to start off with. You need to also do that at the very outset. Check. If you need third party license, and if that third party license for the technology needs to come all the way to your JV company, you will need to have ancillary agreements for that license to be given to you as well. Okay. And reputation and track record, as I said, the due diligence will show you if they have track record and what their reputation is. So normally you have JVs. Why? It's because either they can bring in the funds as a financial investor or co-investor, or they have technology expertise. Okay. So next slide. Okay. So another aspect of JVs that we've seen is this cut-off date. Okay, so kita ada CPs kan. So okay, parties agree to a fixed period of time for CP. But what we notice, there seems to be continued extension. Macam no ending to the CP period. Now what we have to caution you is, in the agreement, 1, you must put the cutoff date. 2, kalau extension, you must also have a fixed extension. Mutual extension, not more than maybe once. If you keep extending, it can be construed as parties have that intention to just keep extending the cutoff period. So your cutoff, your CP clause, your cutoff for the CP clause, when parties will walk away, is very important. You must make it clear in the agreement. Yeah. So the problem we see selalu kadang dah extend 3 kali, no proper written extension or mutual agreement. It's all verbal, and then it can be construed or implied that you've always agreed to just keep extending the cutoff period. Kan? And termination due to non-fulfillment of CPs. Now, another thing that we see is common. Now, PKNS, we know, is a government owned entity, state government owned. And your anak-anak syarikat indirectly are also government owned entities. So, when you deal with third parties, if there are governmental approvals, they say, PKNS punya anak syarikat kan, PKNS, state. Kalau nak kena ada approval, bolehlah you all dapatkan. Why do we need to rely on any other party? So if, although you know that you are independent and you cannot control and you cannot dictate to the state authority to give you approval. But the JV partner who looks at you as state-owned entity thinks it's your obligation to get that CP. So what we will caution is you must always have clear terms to say that these are CPs which are not our obligation alone. Parties have to work towards it. If any governmental approvals are not obtained, it is not our liability. We will not be liable for it. Okay? And also the other thing is about having the right to explore alternative partners. If you don't have that clause in your agreement, that if as at the cutoff date it's not obtained, you can walk away and look for other partners. That's also something that needs to be there. Okay, next slide. Okay, this is on management and governance. What we often see is the formation of the board. JV partners as shareholders will want to have the right to nominate board members. That's right. Okay, that's fine. But you have also the shareholders' interest. As a nominee director, you will want you owe your duty to your shareholder, right? But actually, that director has his responsibilities and duties to the company. And that's something kalau you all act as nominee director for your employer lah ya, PKNS or the anak syarikat, you have to remember that your duty is first to the JV company. So to avoid a situation of conflict, we would advise that you have at least independent appointed directors onto the board. Okay, so that independent director can act as the apa ni, macam the vote caster in the event of an equality of vote or in the event of a deadlock situation. Yeah. And then the other thing is, apart from board members, what about your key personnel? One thing we have to caution key personnel, kalau you are having a JV with technical providers, the technical providers which we've seen in one of your JVs, technical provider dictate they want to have control on nominating and appointing the COO. Okay, now it's fine if they have the technical expertise and they are seconding that officer over, but be careful about the control of the COO. Some JV partners try and input a clause to say that COO will only take instructions from that JV partner for technical issues. Now, that's very wide. Technical issues to apa, right? So it can fall, anything can fall under that. And they will have control over what sort of technology they also share with the JV and with you as a partner. So when they try and put in clauses where they will have full control and management of any particular key personnel, there needs to be clauses that allows you to access and have participation in the meetings. Okay, so, and then as shareholders, because you have no rights in law to access records of the company, you must put it in the agreement that you have access to the records. They've got to send you periodic reports, and you can participate and in committees, for example, on the operational level. But that has to be in the agreement. If it's not in the agreement, you don't have it as a shareholder, even if you're a majority shareholder, basically. Okay. This is, I think, something everybody knows, right? Board reserve matters, key matters on the company that you must have to ensure you preserve your management rights. Okay, so that I'm not going to go so deep into that. This is the common list of reserve matters that we see at the board level. The difference between shareholders reserve matters and board matters is, one is the day-to-day management of the operations is with board matters. So business plan, financial planning, budgeting, that has to be with the board. For the shareholders, it's any transaction that will have impact on your value of your shares and any impact on the returns on your investment as shareholder. So anything that can impact on revenue, on your dividend rights, then that goes up to shareholders. Anything that's got to do with diminution in asset or reduction or taking away of value of an asset, that goes to shareholders as well. Okay, winding up, of course, goes to shareholders as well. That's a normal reserve matter anyway. So, but there may be, apart from the general reserve matters, each JV or each operation has peculiar aspects, kan, depending on the nature of the business. So, for example, if it's got to do with a manufacturing aspect, then you also want to ensure that whatever agreement they enter into with your JV partner, who is the technical provider, is a related party contract, and you must have a veto power over that contract. Okay, so related party contracts, I think you need to pay particular attention to, depending on the business of the JV company. Okay. Before we go to deadlock, I just want to caution risks, yeah, because it's all about risk management at the end of the day. The risk allocation is very important as far as the parties are concerned. And otherwise, you will come to a situation where you have a deadlock. If you don't have risks and responsibilities ironed out as to who's responsible for what, you will come to a deadlock situation where parties cannot move any further in the JV. There's a breakdown in the relationship. Parties cannot come to a consensus on matters that have gone to the board, for example. Yeah. So deadlock mechanism depends on whether or who is in a stronger financial position. Okay, because a deadlock means either you wind up the company or you have an exit option. The exit option has to be either you can buy the other party out or the other party has to buy you out. So you have, it depends on what is the asset. Do you want to preserve the asset with yourself and not let it go to the JV partner? And two, before you decide you have to buy me out, okay, that will be depending on whether you want to keep the asset. Two, if I'm going to buy you out, do I have the financial ability to do so? All right, because you can have that provision in there, tapi when it comes to you having the right to call for them to sell their shares to you, you are not able to proceed with it because you don't have the financial ability. So on that point, if there are assets that PKNS or anak syarikat has contributed to the JV, it may be worth having a separate agreement for use of that asset rather than putting that asset into the JV itself. Because once you transfer that asset into the JV, it belongs to the JV. You cannot say, I want it back just because I want to walk away. And I'm not in a position to also buy you out so that I keep the asset with myself. So what you should do is you look at the nature of the asset. You either have a license to use, a right to use, a lease, that sort of arrangement if it comes to property. Yeah. So this is also an extension of your rights to the shares. So dulu, normally when a shareholder wants to sell shares, you only see right of first refusal, right? That's quite common. Everybody has heard of the phrase right of first refusal. Now, right of first refusal now has been seen to be more beneficial to the non-selling party. So because it's my anak syarikat, I hold majority shares. If my JV partner wants to leave and they want to sell their shares, they have to offer it to me first and I buy you out. Okay. Now, and normally in that situation, they would have had a third party price. They come to you and say, okay, I've got a third party who wants to buy me out at 100 ringgit. Okay. And they offer it to me and I can buy at the same price. Okay. Now what to the selling shareholder, it has been seen as something that's not advantageous to them, because if they want to walk away, they would have gone out to look for potential buyers. There would have been a lot of cost, a lot of work and effort involved in getting potential buyers, but then actually they cannot sell to the potential buyers because they have to offer it to you first, right? So the other thing is potential buyers also will not put in a value because they say, why should I put in the effort to try and value your shares when you don't have the right to sell to me first? So now what sellers are looking to do is they're doing a right of first offer and a right of first negotiation. Now, this is a tactic where they come to you and say, I want to sell, give me an offer. You give me the price. And if your price is not good enough, I can say no, and I can actually sell to a third party for a better price. I don't have to come back to you to say, look, I've got a better price. Are you going to now buy me out at this price, right? So what we have seen, what we have advising clients, have a hybrid. don't stop at the ROFO or the ROFA, but have a ROFO first. You have a second layer. If you get a better price, come back to me and give me a second option to consider whether to buy or not. Okay, especially because kalau ROFO saja, but that one you will see a lot of aggressive discussion on that, because now we're seeing third party investors just want a ROFO. They don't even want a ROFA because they are in there to just sell the shares and walk away. Right? So they just want the best price and they'll just walk away. But you, as the owner of the project or owner of the JV, you want to preserve, one, your ownership rights of the asset, and two, you don't know who they're going to bring in as a new shareholder, right? So we need to maintain that. So that should be your negotiation point. Your negotiation should be, look, this is a JV. I'm going to bet with you. Sorry for the example, but yes, I've decided to have this relationship with you. You cannot force me to get into the relationship with someone else that I don't know. So that should always be the starting point if you want to preserve the asset. Yeah. So I think permitted transfers, that's another thing that we have to bear in mind. From PKNS's end, or as a big group of companies, you will want to have rights to restructure in the future. So if you want to restructure your asset, you must maintain the right to be able to transfer your asset to your related corporation. And those are the permitted transfers. Now, what is the extent of the relationship? That is on a case-by-case basis, but normally we will just have an unlimited or unrestricted extent as long as it's to your related corporation. On the converse, when you allow this, because if you allow this for yourself, the other JV partner is also going to say, okay, I'm also allowed to transfer my asset to a related party. But what you need to bear in mind is that transfer can be direct and indirect. So it's the indirect portion that you need to make sure doesn't happen, because they will sell it so many layers up. So your provision must be able to cover that indirect transfer as well. All right. The other, of course, the exception to that sometimes that we've seen, and it's something that's always a hard sell, is how do you not grant right to transfer to financiers? Okay, I mean, a lot of times, maybe PKNS being a state-owned, you are in a better financial position, but a lot of times third party, they want to take third-party financing. So they want the right to secure the asset as well, their shares, as well as to transfer to financiers. Yes, you cannot really resist that to a large extent, but you need to at least have the right to approve. With approval not to be unreasonably withheld. Yeah. Okay, transfers to competitor. I don't know if this is going to really affect PKNS as whether or not your JV partner can transfer to a competitor. Okay, or you can transfer to competitor. Okay, I think one that we have seen is where you are going into a new technology. Okay, a new venture where related to, say, for example, a concession, okay, and a concession in relation to utilities or anything else. Now, you have got concession for certain part only of, say, the state, but you also want the concession for the utilities to be given to you for the rest of the state, right? I mean, okay lah. It's basically like apa ni? Refuse collection, So if you have a technology provider come to you because you've been given the first concession, but only for part of the state, and that technology provider can also set up with other parties to give the same technology to the state, then you will lose out on any expansion of that concession. So you don't want them to be able to deal with any other third party if their technology is something that you want to keep to yourself. Okay, so that's a situation for restriction of shares to competitor. Okay, third parties. I think we've talked about it. It's normal to transfer to third party. You need prior consent. Okay, so with regards to transfer of shares, again, depending on whether or not you are in the minority role or majority role. So far, we've only seen PKNS or anak-anak syarikat PKNS in the majority side. We've not seen you in the minority side. So if it's in the majority side, and if you want to sell your asset, of course, nobody wants to buy your shares and have problems with the minority shareholder, right? So you will want to have the right to say, if I'm going to sell, I have the right to drag you with me to sell 100% to the investor, okay, or the buyer, because the buyer sometimes won't want to buy if they have a 20%, 30% shareholder that they have to deal with. So it will also enhance the value of your shares. Your 70% value, if you can drag the 30% shareholder with it, it can help enhance the value of your 70% that you want to sell. Okay. But if you're on the converse, on the minority side, then if a majority shareholder, all right, or even if it's not in a minority position, earlier we talked about ROFO and ROFR. So if you have a right of first offer and they don't accept and they sell to someone else at a better price, then it may be that you want to tag along and say, you must also make sure that that third party gives me the same offer for my shares at the same price. But that only works if it's an asset you can, you can dispose of lah. Kalau asset you want to hold on, then obviously it won't work. But that will get you at least a better price if you can tag along. If you can tag along, they don't pull you with them, but you have a right to say, I want to sell, and you must make sure an offer is made to me as well. Okay. Okay, so termination, I think, is something that we've heard from time to time. Whilst the JV is going fine, okay, everything's all right, very good. Tapi bila relationship has broken down, what happens? How do you terminate? Termination in the event of a breach is easy, okay? But termination in event of deadlock, termination in the event where there are actual other connected contracts which have been terminated, you need to ensure that your agreement provides for that, okay? So material breach is quite clear. Winding up or dissolution of liquidation of the other shareholder is also quite clear. Change in control is something that is not common, which we would advise you do. Because again, when you go into a JV with a partner, it's not just the technology they can bring, it's also their work culture, their corporate culture, and their corporate values. It has to be aligned with your corporate values. If they have a change of shareholder at their level, and there are policy changes because of that change of control, it will have a misalignment to your JV possibility. So, kalau there's a change of control, you want to also have a right to say, look, if there's a change of major control at your level, we want to have the right to buy you out, or you have to sell to us. Okay. Termination event relevant to circumstances or project is in a concession agreement. For example, you have a master agreement, but you also have JV to carry out that concession. If the concession terminates, this has to terminate. Similarly, any other principal agreements where the JV is riding on, you have to make sure that you have to have the co-terminus termination. Okay. And what happens at termination? Okay, so you have to, you want to exit on termination. Winding up will be something that you can consider, but you have to be careful. If you don't provide for it in your JV agreement that you can wind up, you cannot wind up unless you have 75%, right? To go for voluntary winding up. So a winding up provision should be there as a possible termination consequence, so that you force the other party to also go for winding up. Okay. Pricing for termination, depending on whether or not there's a defaulting party or non-defaulting party. on a defaulting party, we would advise that it should be at a discounted value lah, that you can buy them out, right? Or you can sell to them at a higher value. Okay. This is just other additional clauses in a JV, which is normal. Your exclusivity clause, collaboration. Kalau you want the right to be able to talk to any parties whilst you are in discussion with this party, you must make sure that you have that express agreement. Restrictive covenants. Basically, it's about non-solicitation, non-competition. This is more on your side, because kalau there's a transfer of technology by the JV partner, they will tell you you cannot solicit their employees, you cannot compete with them, you can't solicit their customers. So you need to make sure that the limitation is not so wide. You can allow for, we've seen JV contracts where they do allow a certain amount of solicitation, or rather the prohibition is restricted. It's not so wide, because then otherwise it will impact you even when you terminate the JV. Okay, and then ancillary agreements. What we're saying is a lot of times we see JV CPs will say, if it's a lease on a land that you need to also have, the CP will be that parties or the JV will enter into a lease agreement with the landowner on terms to be mutually agreed between the parties, which is very wide. So we always advise clients, if there are salient contracts, either technology transfer, service provision, manpower supply, lease agreement, you should have the salient commercial terms already agreed and attached to your shareholders agreement or JV agreement, so that when the time comes for you to do those agreements, your salient terms cannot be renegotiated, cannot be reopened. So those salient terms you need to identify even at the time you do the JV agreement, not subsequently. Okay, because we've seen many times where the parties cannot agree on the commercial terms, or what has been promised before, suddenly after the shareholders agreement has been signed, the other party comes back and says, oh, actually, I want to change A, B, C, D, E. And we've seen this just recently with one of your JVs, actually, one of your anak syarikat JVs. So that's basically all on the JV agreement. Now going on to privatization agreements. Okay, so depends on what the scope of the privatization or concession agreement is. Is it a build, own, build, operate, transfer, or is it a build, own, operate, transfer? Those are the two common types or structures that we've seen. Now, the allocation of risks, this is where, again, in a privatization agreement, what we have seen, depending on whether or not your anak syarikat is on the part of the concessionaire, or are you looking at being the state-owned entity that is then giving out to a private party? Okay, so more often than not, we've seen it from the concessionaire's perspective. What you have to be very careful about is how you allocate risks. Some risks you can take on wholly because you can manage it. Some risk you can't. So, for example, if you have a project and these are basically the risks that you look at. Okay, so your political risk must always be with the government. Okay, you cannot have a clause which says the government can go ahead, if there's change in policy, just terminate the agreement. Okay, that's the risk that you have no control over. So the government should be able to promise you what would be the compensation if that happens, if there's a change in law, sama. Okay, or for example, if there's licensing or permits or permission to be obtained, it is a government contract at the end of the day. It's a government project. So that political risk on getting those permissions or approvals should be with the government or the state. The period of time for the concession, again, is something that is not within your control, so should also be promised upfront. If there's going to be other ancillary agreements that the government has to procure, for example, federal land commissioner to give you land, it's over a lease period, it should be coterminous with the main concession agreement. If there's going to be fees or collection of fees, for example, if there's going to be statutes or regulations that need to be passed to ensure the government has the right to grant you this concession, you must make sure that the government takes the steps to issue the necessary regulations, pass the necessary gazette subsidiary legislation to ensure that you have that grant, because this will also affect the bankability of your project, right? If your grant is questionable, then two things. One is your rights and your enforceability rights against the state is questionable. Two, it will not be bankable as far as the financiers are concerned, because they'll question, do you really have the right to do this grant for the next 30 years or 35 years or whatever? Okay. So those political risks you have to pass to the government and make sure in your privatization agreement, the government can get those for you. Your construction risks, I mean, PKNS being in the construction industry and very experienced, you know what your construction risks are. And always ensure that the construction risk is passable to your contractor. Okay, and if it's the contractor and any other levels, you just have to make sure that it comes back to you having the right to go after not just the contractor, but also the subcontractors and the nominated contractors. For the project risk and the performance risk, that is pretty much interrelated, because as an operator in the concessionaire, as the operator, you just have to make sure that your obligations to perform what you are performing, because what you promise to perform has to be very clear, and whether you can perform the promises that you have promised. Because at the end of the day, it all goes back to the project risk. Because if you don't perform and you don't deliver what you promised to deliver, it is of course going to lead to a termination. Okay, and not only that, it's also reputational risks that you will have. Okay, for any other project or concessions that you want to obtain. Going back to the earlier slide. So just on this again, after you've identified all the risks and how these risks must be dealt with in your concession agreement, because a lot of times we've seen concession agreements where, I mean, most of the time it's all regulated now, it's all standard templates from UCAS, from UPenn, but there are some terms in there which are very one-sided, as you all would see, and you should try and negotiate as much as possible to take away the risk from yourselves. One other point on novation and assignment. Okay, a lot of times the concession is given to the parent company, okay, or the holding company, because that's the company that has been lobbying for the concession. But you cannot then create subsequently an SPV, if you want to create an SPV, and novate those rights, obligations, benefits of that concession agreement to your SPV. Now, and what we've seen is you can't then ring fence your project from the holding company, because the SPV does not have the full rights to the novation of the agreement, full rights to the assignment of the benefits, and therefore cannot get financing because they don't have the full rights. So your novation and assignment clause must be negotiated as tightly as possible. Don't accept the general UPenn, UCAS punya clauses. And we have seen situations where we've managed to negotiate out of those strict non-assignability punya clause. So when you are entering into the privatization, the concession agreement, you already need to bear in mind at the outset, are you going to set up an SPV or not? Because if you're going to set up an SPV, then you need to ensure that you have the rights to transfer the whole agreement to the SPV. Duration of the concession, we've talked about it. So duration of concession is one thing. It's not just the concession itself. If there's any other ancillary agreements for the right of use of land, for example, for utilities concession, you need to have it coterminous. Because land issues for utilities under the National Land Code, there is a limitation as to the period of time that the lease, the maximum period the lease can be granted. So your concession can be 30 years. But your land under the National Land Code for the Gazette, for the right to use, has a limitation of only 21 years. What happens to your 9 years? If, say, at the end of that 21 years, the Federal Land Commissioner doesn't give you the extension of the lease. So what we've advised clients is you sign up a new the extension agreement now, but the extension agreement will take effect for the extension from that end of the 21 years till the end of the 30 years. So bear that in mind, because it's not necessarily coterminous under the relevant laws. And then financial costs, of course. I mean, in a concession situation, it's always the financial burden will be first with the concessionaire, but you must have the right. What is your right to actually get reimbursed for the project? So these are the main factors that you need to just ensure in a concession situation. The regulatory framework, as I said. Let's just give you an example. Macam the highway concessions dulu. When the highway concessions were first introduced by the government, there was no statute or regulatory legal framework allowing the government to allow a third party, private party, to collect tolls on the use of public roads, because highways are considered as public roads. At the end, it's done for the government. So they had to actually pass a law to allow for the government to collect those tolls and to also grant to third parties the right to collect those tolls. So that's just one example. So when we are looking at concession, depending on what utility, because it's always about public service. All right. So if that public service is under current act or statute is only with a government agency, we have to look at that statute to see if that government agency has a right to delegate that statutory authority to a third party who is a private party. If they don't have that right, you must ensure that the government pass the necessary regulations to allow that or to amend that statute. Otherwise, your rights are questionable and can be invalid and therefore terminated due to invalidity. Okay, so you've got to ensure that your regulatory framework is there. And of course, government support. I mean, as always, in any concession agreement, as long as there's government support, strong government support, you can always get them to make the necessary changes for you that will help in the concession agreement. Clarity of project formulation and documentation. Again, it's just how clear your concession agreement is in relation to duration, restrictions and limitations, the scope of the works, payment terms, whether or not it's a fixed payment term on a revenue basis, frequency and penalties for late payment, because we've seen a lot of clauses on penalties for late payment on the revenue. Identifying responsibilities, I've said it earlier already in the structure on the risks, termination events, circumstances and consequences, and also dispute resolution. So those are really the key points. One of the main impacts that we've seen in concession agreements is where there is a change in law and the parties did not anticipate it. So if there's a change in law to actually take away some of your rights, because you will always have a clause to say if there's any provisions in this agreement which becomes invalid or restricted by law, then only that provision will stop operating, and the rest of the agreement can continue. So if you have a change in law that affects any part of your performance or your rights or your benefits, you don't want to have to continue with the rest of the agreement if you don't get the full benefit of the concession that you had anticipated from day one. So you have to make sure that you have a right to change the terms in the agreement in the event there's any change in law. Not a right to walk away, but change in terms in the agreement so that you can get the full benefit and advantage from that change in law. Yeah. So you've got to ensure that that's change in law clause is in your concession agreement as well. Finally is I guess expropriation and step-in rights. If the government has expropriated your land or asset or project, or if the government has in the agreement granted itself step-in rights in the event you have breached your obligation, please ensure there's compensation. So a lot of times we've seen where no compensation except for antecedent breach. Government can just step in, take over, and not pay you any other compensation, okay, other than what's already owing to you. So we need to ensure that although the priority is there with the government, because it's a government project, government will always have the step-in rights priority. You cannot avoid that. You cannot take away step-in rights, but you must make sure there is compensation provision in there. Yeah. I think that is at the end. Yeah. Okay, so that is basically the end for the joint venture section on the terms of the agreement. I will pass you now to Wai Fong, who will highlight to you the common problems and how you should have those dealt with in the agreement. Thank you.
Salam sejahtera semua. Selamat pagi. Terima kasih atas jemputan hari ini. I will speak about managing litigation risks. Clients sometimes tell me that they don't like to see me because when they see me, it means a problem has arisen. That's not true. That's not the correct perception. Yeah, litigation risks, where although you cannot avoid it completely, sometimes litigation is filed because there is a genuine dispute. But sometimes the parties file litigation to gain some strategy, to gain some advantage, maybe to force an exit because maybe the project is no longer so profitable for them. They want a way out of it. They will try to cari issue, cari pasal, we say, okay, to then write you long letters to say we are going to court to threaten you. So there are ways in which you can try to manage these things by maybe looking at some of the clauses that I will highlight to you. Okay, we will start with joint ventures. Joint ventures, typically it is entered by way of a joint venture agreement. Sometimes there is a shareholders agreement. Preferably, we will suggest you have both because they deal with separate things. For joint venture agreement, it should regulate the matters of the joint venture company, responsibility of the management for the joint venture company, responsibility of the board of directors for the joint venture company. Shareholders agreement, then it deals with the shareholders. What is your right? If there is a majority, minority, then the dynamics are different from if you have a completely equal partnership, 50-50. That can have a different implication when you go to court. Now, what are the clauses that typically become problematic when there is a dispute? I'm just going to highlight these are the typical clauses that people will dispute. So perhaps when you are negotiating the joint venture agreement, these are the clauses that you should pay attention to, because if people want to look for issues, then these are the clauses that usually people go to. Responsibilities, clauses that deals with responsibilities of the respective joint venture partners. Now, what are they? Project financing is one of them. For project financing, usually for joint venture agreement, you will find one party having to have the responsibility to look for project financing. For example, if there is a joint venture project to build something, perhaps usually PKNS will supply the land because we have the land bank. Your joint venture partner perhaps is someone that have the expertise to develop the land but don't have the means. So during negotiation process, what can happen is they may ask PKNS to maybe financially support them. If a decision is made internally that you need to sort out your financing, that means your joint venture partner will then need to go and get financing from bankers. Now, when a joint venture partner, when the joint venture have to deal with third party, macam bank or financial institution, you cannot have control over the timeline. Yeah, whether that financing is approved or not, it's out of your control. It's entirely up to the bank. But you should still have clauses that governs what are the circumstances in which your project financing, you can apply for project financing. What is the timing in which you are expected to get it done? Your joint venture partner cannot always come back to you to say, oh, itu bank belum approve, it's not my fault. That cannot keep going on. You need to set a timeline in your joint venture agreement. If the timeline is delayed, then what happens? And the bank is still sitting on it. Legally, you can, if it is a responsibility that a third party is entirely with a third party, it's not within your control. Sometimes that party that has responsibility to do that obligation can then fall back on force majeure. Force majeure will help them say there is no breach because it's out of my control. So these are things that you need to look out for. Force majeure is a legal concept that allows a party who has not complied with their obligation to not have to breach the agreement. Force majeure help them justify non-performance. This is something you need to look out for. How to invoke force majeure? This is where you also tie in with the force majeure clause. You need to have a clear force majeure clause on what are the circumstances in which that other party can invoke force majeure. If there is a force majeure, they need to give you a notice. When must that notice be given? Next, I move on to regulatory or state approvals. Same issue, same problem, because regulatory and state approvals are entirely the government's responsibility. But sometimes, because you're dealing with non-government entity, for example, most of the time the wrong perception is that, you're PKNS, surely you can get approval. But that is a wrong conception. And in law, they are regarded as different entity. We don't give assurances that we can get approval just because we are part of the state government. It is not left hand must know right hand what right hand is doing. It is not that sort of situation. So for regulatory and state approval, there is also a timing issue for us, because usually in the joint venture agreement, if government or state approval is needed, your joint venture partner will expect you to go and get those approval. On the basis that we are part of the state agency, it will be easier for us to get the approval. They will supply us with the documents that is needed. So usually you will find yourself being put in a position where you have to go and get approval. But you cannot assure them. So don't be careful with representation. Don't give them representation that you are able to secure this. Don't give them representation whether it is in your agreement or whether in your discussion with them. Be careful with what you say during meetings. Don't give them assurance like, for example, oh, don't worry, this is just formality only. I know so and so and so and so. We have had the EXCO meeting. It looks like they're giving us the approval. Don't even say things like that. Make sure it's not documented that you say things like that. Okay? because government approval is out of your control. I think that is the mindset we need to have. But what about timing then? Because, you know, sometimes when you apply for government approval, we cannot control the timing. Yeah, although we have relationship with them, we can push for it. We cannot control the timing, and timing cannot go on indefinitely. So when you negotiate the agreement, you may want to anticipate how long usually this process takes. If I need more time, there should be maybe an automatic extension of time we build into the agreement. But what if you cannot obtain the approval eventually? Do you want to include in your agreement to say, I get automatic extension, maybe 2 extension at most, but there must be a cutoff for yourself for project planning purposes, because you also don't want to wait indefinitely. This has a tie-in with your value, perhaps. You may have your entitlement calculated in a way. The longer the project takes, the market situation changes, the price also changes. So these are things that perhaps you can plan when you're negotiating the agreement. Fix a timeline. If that timeline doesn't happen, then what is the consequence? Force majeure will only help you to justify delay. But if the government tells you that your approval is denied, then that is not force majeure anymore. It becomes a situation where you can say the contract is terminated. But it will be better if there is a proper clause in the joint venture agreement itself. Okay, then we move on to equity injection. Being the party that has the financial ability, that is how your other party will look at you. They will look at you as the party that is able to inject equity. So you need to spell out very clearly circumstances in which you are prepared to inject equity. Okay, now be clear about these circumstances, because if the circumstances are too wide or too vague, the other party can take advantage of it. If the other party wants to get out of the agreement, they can write you a letter to say, you have an obligation to inject equity. This is now the circumstances for equity injection, but it's not in the agreement. Then what do? You will find yourself in a difficult situation, because the contract says you are the party with the responsibility to inject, tapi it doesn't spell out what are the circumstances in which you inject equity. But your obligation is there. Then it becomes a matter of argument with them. Yeah? And typically, if the clause is not clear on equity injection, party will use market condition to justify equity injection. They will say, look at the earnings, look at our audited accounts. The earnings have gone down, projection revenue for the next 5 years is low, the market condition is this. If we launch the project in 5 years, you are looking at minus 20% from our initial projection. This is the time for equity injection, because we can buy materials at lower cost. These are the sort of reasoning that you find yourself having to deal with if the clause is not clear. So spell out the circumstances as clearly as possible. But this one requires perhaps an assessment of risk at the outset. What are the risks you are prepared to take? At which point in time you are prepared to inject equity? But always keep as much as discretion to yourself, if possible. You can make it a board reserve matter for discussion. But at least spell that out. Because if you have responsibility, tapi the circumstances is not clear, then you may have a problem later on. Next clause, of course, is responsibility of management. This is a bit difficult sometimes, because the management is meant to run the day-to-day operation of the company. So if we see the memorandum and articles of association, they usually say managing director has responsibility of day-to-day operation. But what is day-to-day operation? Getting a loan for the company also is a day-to-day operation. And it becomes even trickier when you have a board with different dynamics. What if your board consists of 3 representation from majority shareholders, 2 representatives from the minority shareholders, and the managing director is closer to the minority shareholder and take instructions from the minority shareholder behind your back? because typically you find yourself as the majority shareholder. How do you then control that? You need to keep in mind for management, the management's responsibility is to the joint venture company. It is not to any particular shareholder. So the board needs to keep a close eye on the joint venture company. The board needs to be clear on what are the reserve matters that only the board can decide. Big ticket items, especially loan, project financing, these are things that you need to pay close attention to. It also ties in with a different aspect that I will now come to, which matters from new issuance of shares onwards. Now, why do I want to deal with this new issuance of shares and so on? For joint venture company, if things go wrong, parties want to sue each other, the most common claim that parties make is to file oppression petition in court. How do you argue oppression? The basis of oppression petition is to say the management of the company has been run in such a way that it prejudiced my right as a shareholder. I'm not being treated equally as a shareholder. It's usually an argument that minority shareholders will bring up. They will say management only listen to majority. Because management only listen to majority, my views are not taken into account. I am prejudiced in my position as minority shareholders. So these are the usual clauses minority shareholders will challenge. 1. New issuance of shares. Why is new issuance of shares so controversial? Because when you have a joint venture company, you would have decided on the shareholding at the outset. For example, 60-40%. PKNS take 60%, minority shareholders take 40%. With new issuance of shares, sometimes you dilute the shareholding. The more shares you create, the lesser your minority shareholders shareholding can become. So take perhaps an example. If you have 100,000 shares, split up to 60,000 for PKNS, 40,000 to minority shareholders. If you issue a new share of 100,000, if you follow the 60-40 split, PKNS will get more. Certainly, your minority shareholders will get less, but the share amount becomes bigger. Your minority shareholders will then say, you didn't get my consent for issuance of shares. You didn't follow the provision, or there's no provision. You shouldn't have issued the shares. My share is now becoming smaller because you have more shares. And shares tie in with dividends. The more shares you have, the more dividends you're supposed to get. And dividends come from revenue of the company. So you must be careful with the issuance of shares. What are the circumstances in which new shares can be issued? Incorporate a provision into your agreement so that this is clear. And if there is no agreement, then this is a matter that must be brought to the board. You must get an agreement, or at least the majority, as per your joint venture agreement, in order to be safe before you do that. Otherwise, your share issuance can be challenged as a basis of oppression. Now, transfer of shares and restrictions of shares. I think this is something that Shariza touched on just now. There are circumstances of permitted transfer. If the circumstances are spelled out in the agreement, preferably you do that. If it is spelled out, you will need to make sure it is followed. And the board can decide that that registration is not approved. But this approval cannot be withheld unnecessarily. So if your permitted shares provision are not clear, and your joint venture partner has then divested the shares to various minority shareholders that you actually don't want to partner with, how do you stop them? You stop them at the board level. But at the board level, you can only stop them if it is reasonable to do so. What is reasonable? If you go to court, the court will tell you what is reasonable is a question of fact. That is what the litigation lawyers like to say, because it is not clear. question of fact means the judge will decide. The judge will look at the entire circumstances of the case. But for you as the client, this means uncertainty for you. Because all we can tell you when you come to us at that stage is it is based on circumstances of the case. Then you are going to ask me, what is circumstances of the case, Wai Fong? I'm going to have to tell you this depends on the judge. That is not satisfactory at that stage, isn't it? You want some certainty when you're stuck with your JV partner already. And what are circumstances of the case? The court will look into the running of the company and so on and so forth. And you may not want to reveal everything in court either, because certain things is a bit sensitive. You want to keep it P&C. So these are things that are a bit tricky to manage if the clauses are not very clearly spelled out. But do look out for this kind of issues. Next will be declaration of dividend. This, we would suggest that you look at it from the outset, whether you want a clause on declaration of dividend or not. There are pros and cons. If there is an express clause on declaration of dividend and it is not followed, it can give rise to oppression, because the revenue of the company can only be taken out by dividend. That is one way of taking out revenue of the company. If you have an express provision or an express fixed policy for declaration of dividend, it has to be followed unless there are exceptional situations why you cannot. If it is not followed, your minority shareholder will say, you're depriving me of the remuneration. You're depriving me of the revenue of the company. You're siphoning money. These are the usual allegations we hear. So if you have an express clause, you decide to have an express clause, the risk is you have to stick to it unless there are exceptional circumstances. Those circumstances preferably spelled out. Perhaps you can incorporate a formula. If the revenue is X amount, there need to be at least Y amount of reserve for future operating expenses, for future project. Spell it out. Have a formula with you. When it comes to monetary policies such as this, we do appreciate it's very difficult for you to have circumstances spelled out A, B, C, D. You want some flexibility also. Perhaps you can look at the formula. But if you don't decide not to have a dividend clause, then you need to monitor the management closely. Because if there's no dividend policy, you cannot go and demand for it every year as a matter of right as well. So there are pros and cons. Now, events of default and termination, of course, you must strictly comply. I think what we've seen in perhaps your version of the agreement is that most of the time for events of default, it is based on breach. So you need to find circumstances of breach before you can terminate the relationship. But what if there is no breach, but you don't find that synergy anymore? This is something that perhaps you should explore at the outset, because if your events of default clauses only cater for breach, you need to find that breach to exit. And your joint venture partner need to find that breach too, to exit. And breach sometimes is not as easy as we say. Yeah, you cannot issue a notice to terminate a joint venture agreement by making allegation that you have breached without specifying what those breaches are. So you need to be careful. This is where I think for legal perspective, there is a need of perhaps a collaboration with the operational side. If there are operational parameters for your agreement, monitor those timelines closely. The minute the timeline is not complied with or documents is not given to PKNS, flag it out, because then you can build up this breach for your side if you need to rely on it. Put it down all in writing. Now, what are the remedies upon occurrence of events of default? This should be spelled out as expressly as well, clearly. The common ones that we see that becomes an issue is your call option. If you have events of default, parties would want to get out. there will need to be a call option, and be clear about the formula, how to ascertain the value. Because you're talking about exiting a partnership where you have shares. That value becomes an issue. You want to have a formula to calculate that value. And sometimes we cannot anticipate when it happened. It may happen 3 years down the road, 5 years down the road. Market condition changes again, that it impacts your value. So have a formula. A common one that we see is have a formula where it is assessed based on last 3 years audited accounts, for example, and the value to be ascertained by an independent accountant. That can work if you are prepared to accept that sort of formula. The other remedy that is common, because it is a joint venture, you want to wind down everything, is winding up. But do provide for it, because as Shariza has mentioned, if there is oppression, then winding up is an option. But unfortunately for oppression cases, it is usually the minority saying that they are being oppressed by majority. Yeah, it is very difficult for you as, say, 80% shareholder to say you are being oppressed by the minority. That means perhaps at the negotiation stage, maybe you didn't put in enough board representation to control the direction of the company. So if you're majority shareholder, you must insist on having more board representation. You need to have better control of the management. So it's very unusual for us to see we met so and so, we met so and so. Have it all documented to show we have acted to comply with our obligation. If you have all this, the other party will not be able to then say that you failed to get state approval. Because your job is to apply and try to get. Your job shouldn't be to assure them you will get it. Okay, so have it all ready. I think it will help manage the risk if you are being sued for failing to get state approval. So again, if there's a delay, make sure you think about whether you want to invoke force majeure. But if the state tells you it is impossible to give you the approval because the landscape has changed, then you need to consider termination. But act as soon as possible if you want to do either of these, because you have to notify the other party. Now, matters to note when dealing with dispute of privatization agreement, I'm going to zoom in on these specific matters. Whatever I say earlier about documenting your meeting, all that still applies, yeah? That is general advice for any agreement that you have. But what are the things to note when you deal with specifically for privatization agreement? A lot of the privatization project that PKNS has is land related. So you need to pay special attention to these things. These are all land related issues. Now, when you have a dispute, these are things that you may need to keep in mind. The other party, who is usually your developer, the land belongs to us, they will want to stop you from talking to a third party because they want to keep the channel open to talk to you. You can expect them to run to land office to lodge a private caveat to stop you from dealing with third party. Once a caveat is in land office, the land office register will show there is a caveat. So if you are trying to sell the land to a third party, any reasonable third party will go and do a land search to see whether that land that PKNS is talking to me about is PKNS land. They will see that it is PKNS land, but there is a problem. There is a caveat. If there is a caveat, it is very difficult to convince the buyer or the next developer you're talking to come into that land. They will know it's very leceh. Firstly, they need to remove the caveat. That takes time. You need to either deal with the registrar of titles or you need to run to court. Our experience in removing private caveat, going to court, arguing, takes at least 6 months. If we chase the court, parties file everything, it's about, I think 4 to 6 months is a safe time period. So you need to remove the private caveat. But what if PKNS is no longer interested in developing the land at that point in time? And perhaps the market has changed, it's more profitable to sell the land to another party. If you want to sell the land, caveat also is a problem. Buyer looking at a caveat will know that it's very difficult. If they buy the land from you, they have to go and remove the caveat, and they don't want to do that. And if they take time to buy your land, it may impact what they want to do with the land too. Or they may buy the land, they may still buy the land from you, although there's a caveat, but they are going to say it impacts the value. Then you shouldn't ask for X amount. I will have to insist on a lower amount. So that has an impact on the value as well. Now, when you have a privatization project, when there is a risk of dispute, you will also need to look out for possibility that the other party will go to court and get an injunction. This is like perintah halangan, to stop you from dealing with the land, to stop you from commencing any project on the land. So once you have a perintah halangan from the court, you cannot deal with the land, cannot transfer. You cannot even do an inter-transfer to your subsidiary company. There's nothing you can do with the land until the court dispute is resolved. So these are things to look out for, dealings with third parties. Now, when there is a possibility of dispute, but as far as you are concerned, you have terminated that agreement, can you talk to the third party? The answer is yes. The answer is yes. You can still talk to third party. You just need to be aware of all this risk. If the third party came to hear of a rumor, that PKNS is rumor, yeah, rumor, because it's a small community of that size. People talk to each other, and if it's a reputable developer that you're dealing with, the developer will know, actually A used to be the developer. What happened? There's nothing on the land. Is there a dispute? I better go and find out the dispute. Internally, you will also need to make certain decisions. If you're talking to this new party, do you want to disclose there is this dispute? How much you want to disclose? Because if your previous party dragged you to court and found out you're talking to the new party, chances are they will also drag your new party to court. So these are things internally you will have to decide whether you want to disclose that. If you're disclosing, how much you're telling the new party in your negotiations. Of course, for getting back the land, you will need to start court proceedings for possession of land. These are things that you have to consider. Now, what about financially distressed developer or developer going into litigation whilst they were doing this privatization scheme with you? Is it a ground for termination? Usually, I would expect you to have a clause. It is quite common to have a clause to say, we terminate if your party goes into liquidation. What you have to be aware of on the ground is if that developer is going into liquidation for financial reasons, and that developer for some reason has a copy of your certified land title, you may want to check whether that land has been transferred. What if there is mismanagement by the developer? That's the easiest way to get money, because you transfer your land to a third party. The third party then go and get a loan from the bank. The bank will come and say, no, PKNS shouldn't get the land back. I'm now a bona fide third party purchaser with value. I'm a completely innocent party believing that the land came from this fraudster, we use it loosely, yeah, came from this fraudster. I've given out loan. Now I want the land as security. So that could have an impact as well. So do keep track of how your developer is doing financially. If you think they are not in so stable condition, you need to monitor your whereabouts of your assets. Land especially is valuable. And once you change hands, the law will protect the innocent buyer. So that is where you stand for land. Even if you're talking about our own private property too, you need to take care of land. Once it changes hands, it becomes very difficult to get it back. Okay, liquidation. The moment the company is liquidated, everything passed to the hands of liquidator, which is usually the Director General of Insolvency, Pejabat Insolvency Malaysia. And you will have to deal with them. Their job is to take in all the assets, they sell to everybody, get the cash, then they pay the creditors according to, we call the priority. The banks get paid first. You become, unless they have given you a secured security, you become an unsecured creditor. You line up with everybody else to get the money back. That is if there is any money left by then. Yeah, so liquidation is something you need to take note of. Retention of documents is the same. Keep it for 6 years. Land documents, 12 years. If you want to talk to them without prejudice. Even WhatsApp call, which is quite common these days. That is all I have. We can move on to questions and answer. Thank you.
Thank you Puan Shariza and Puan Wai Fong. Any questions from the floor yang boleh kita panjangkan pada penceramah kita?
Assalamualaikum. Just now you were mentioning on RAW4 and RAW4, right? So basically how I see it, together with the tag along, drag along clause. Sometimes when we go into a JV, it's like a marriage lah, sampai mati lah, right? But sometimes these roffers can be used as a weapon for them to get out from the JV, and they might call up a party, so they put up a high valuation so that I can go to PKNS, I can get a larger amount. So how should PKNS protect itself from this scenario?
Thank you, Nico. Okay, I guess shares are assets belonging to the shareholder, right? So you cannot stop a party from wanting to sell their asset. Okay, and it cuts both ways, yeah? Whether you're in the selling side or whether you're in the buying side. So I think at the end of the day, it's if you want to stop them from selling, you can't stop them from selling. You can only protect yourself as a shareholder to preserve your rights to those shares. Kan? So, so going to your question, how do you stop them from giving a ROFR or ROFO, right? Or triggering that event? There is no prevention as such, because just like how you say, parties go into the marriage together, there is a situation where one party just wants to come out of it as well, right? So the only thing that I can think of to stop a situation where they have to sell to you is that if one party wants to get out, then you have to wind up. But you may not want to wind up, right? Because you want to still preserve the business kind of the JV. Don't know if I've answered that question.
Wouldn't want to be in a position where I have to buy your share.
Correct. But it's either you buy, sell, or wind up. That's the three options that you have. It's like I said earlier, kalau asset is something that you want to preserve, say for example, you transfer especially land into that JV, you don't want that land to go to someone else or that business to go somewhere else. So you need to ensure that you have the right to purchase. You don't have that right to purchase, if you don't want that right to purchase financial organization, then you want to also wind up. You have the right to say, we want to wind up the JV, right? And if I have contributed the land, I will have the first right to buy that land from the JV. That you can have, but it must be in your contract. The first right to buy that asset, because if you wind up, it goes to liquidators. Liquidators will just have to liquidate the asset in a winding up, but you can have the right to preserve just that asset at least. And control, basically, right? Yeah. Okay. Right. So I think as a minority shareholder, you need to identify what are the business aspects that you want to have control over, or at least a veto right over, even as a minority shareholder. Okay? Because as a minority shareholder, what have you brought to the business? There must be benefits you are bringing to the business. So if you want to preserve your right as minority shareholder, first of all is access to information, because as minority shareholder, you will not have that right outrightly. You must make sure your document says all parties have access to documentation. There's periodic reporting on the business. 3, you can have project committees for the business. And although you may not be at board level, because you can also have observation rights at board meetings, you can be party to a project by way of a member to a project committee. You can do that. You can also, of course, at the end of the day, have it as a termination event. All right. So, but that is the absolute you don't want to go to, like, you don't want to terminate. You just want to have the rights before you come to a point where you have to terminate. So those rights as minority shareholder can be put into your contract, into your agreement. And if they don't, if they breach that that provision in giving you those rights, damages suffered can actually be claimed against them. Correct me if I'm wrong. Yes. Okay.
Hi, Assalamualaikum.
Salam.
I just want to get your opinion. Okay. We can't stop any company to wind up or dissolve, right? So, what is your opinion to improve our agreement, to protect PKNS interests, in regarding a company that we join into JV or privatization that dissolve and wind up, because at the early part the obligation is on the developer, but once they dissolve or wind up, it will goes to the liquidator and SSM and so forth lah. So there's also a situation that the obligation will come to the PKNS. We need to deal with the customer, with the buyer, with the land office, and so on and so forth lah. So what is your opinion to improve our negotiation, our agreement to protect PKNS interests? Thank you.
Okay. So that is really more relating to your property JVs, right? Whereby you have joint development and then the JV company sells the residential property or commercial property to third parties. But in that situation, is it the JV party, JV company that is going to be the seller, vendor of the asset? Or are you talking about giving the developer the selling rights?
Most normal practice, we give the obligation A to Z lah to the developer.
Yeah, obligation is one thing. It's the right to sell as well, right? At the end of the day, can. So the developer, yes, and a lot of times we see where the developer is actually just a special purpose vehicle, and then they just go into liquidation before the project is completed, or before the asset can actually be transferred to the purchaser. This would be under the Housing Developers Act though as well. But to protect PKNS as landowner, you should ensure that the agreement, okay, there is notice as far as the purchaser is concerned, that the obligation is to the developer, full obligation as the developer, and they acknowledge that. Okay, as landowner, you still retain title over the land, right? Okay. So if you still retain title over the land, obligation as landowner is still to transfer property to the end purchaser. But the development has not completed and the developer has wound up, katakan. In that situation, my advice would be your choice of the developer, one, and two, as we said earlier, as far as your due diligence on your developer, if it's a special purpose vehicle, you need to get a third party parent company guarantee to yourself. Because as landowner, under the housing developers laws, you cannot really protect yourself with regards to the end purchaser. The end purchaser will look at developer and landowner, but you need to have recourse to make sure that your liabilities is not just your liability, but someone else is going to pay the compensation on your behalf. So that has to be by way of a guarantee, okay, or an undertaking from a parent who is more financial worthy. Don't just enter into an agreement with a developer, which is SPV, which has nothing in it. It's got worth nothing. If it is going to be a shell or an SPV, get a third party parent company guarantee from that developer's parent company. Okay.
Any other questions?
Assalamualaikum. Alright, my name is Fairul from Academy PKNS. So I would like to ask pertaining to the in terms of our investment through dividend. So is it a practice or is it a normal practice for a JV partner to agree, okay, if they can take out the revenue from the gross sales instead of from the dividend? From the sales of the, I mean, the revenue from the sales.
So direct sharing of the
Correct.
profit or the revenue
Yeah, not
at the
through
outset
dividend only.
instead of
Right.
through dividend.
Yeah.
In law, that's not regulated, so it depends on your commercial terms. It is purely contractual. Yeah. So it's how you negotiate that. I mean, we would of course advise you shouldn't allow it, Lakan. But we have seen, I think, agreements where the marketing party says they want to also have a share in the actual sale proceeds. I think it really depends on reliance on that party. How much do you rely on that party? How much of that marketing obligation is totally theirs? Because they will want some returns immediately before they put in all their effort, kan? So I think it really also depends on how much of that obligation on the marketing and selling part that you share with them. Yeah. But in law, there's nothing to stop that from happening.
Ms. Wai Fong, I have one question that just now you mentioned regarding recording, that we require consent from the other sides that we meeting with. So if we record it without consent of that person with the quorum of the meeting, so does it require additional method to admit that recording as an evidence in the court?
Okay, preferably you have the consent for the reasons I've mentioned earlier. If you don't have the consent of the parties, but you want to record it quietly, you need to make sure that you use a device to record. And once you record that conversation, that device must not be tampered with. Because when you send it for authentication, what they do is they do a forensic analysis of the voice. They need the original device. So you must not tamper with the device. When you have the recording already, do a quick process to upload it to your server. Save it immediately. Document the process. Get your IT head involved. Because we can do one of two things if we want to use the recording. One, we send the original recording to the organization, the third party, for forensic analysis for confirmation. So they will be coming to court as your expert your forensic expert to confirm the voice. But sometimes it's difficult to confirm the voice because the expert needs vocal samples. Once we are in court already, if you tell your counterparty, I'm going to use that recording, I want the sample of your voice, your counterparty is going to say, no, I'm not going to give it to you. Okay, so getting sample recording is difficult for that reason. But two, the other way in which we can admit it is, if you get the recording, you don't tamper with the device, you save it straight to your server, get your IT involved. As a matter of evidence, we can then get your IT head to issue what we call a certificate under Section 90A of the Evidence Act. The certificate has to say, I am the person responsible for the operations of the server and all computers for PKNS. I can certify that at the material time, the computers were all in good working order. So these are the words we need for certification. But your IT person then has to come and testify, has to bring the original device, has to be subjected to cross-examination by lawyer from the other side. Lawyer from the other side is going to ask about these things. When did you record? What day did you record? When did you save it? So you need to save it as quickly as possible, because if there's a time gap, the lawyer from the other side is going to say, there is a gap of 1 week before you save to server. How do I know what happened in that 1 week? A lot of tampering can happen. But if you come back immediately and save it, then time gap is lesser. We can reduce this sort of argument. So there are two ways.
Jadi Any other questions?
Hi, madam. Okay, I have a question on caveat. Is there any way to stop the other party to caveat our land? Is there in any case, of course, the dispute there. So, is there any way to stop?
To stop a caveat, it is almost impossible because it's very easy to lodge a caveat. All you need is a caveat notice. It is a sample under the National Land Code. You just need to provide the name of the person who is lodging the caveat, state a reason. The land office will accept, because the land office don't assess whether legally you're entitled to caveat or not. That's not the land office job. It is administrative. When they see a caveat, they will put an endorsement on the title. What you can then do as the landowner is to then either lodge a complaint with the registrar to say they don't have caveatable interest because they are not landowner. Even if there's an agreement, it has already expired, we have terminated, we have given notice, therefore they don't have right. You can go that route, or you can file proceedings in court. But you can expect either one of these two things that you try to do to remove the caveat. The other party, you can expect them to file a suit. If they are serious in challenging you, they will then file a suit to say as far as they are concerned, agreement is still valid, so the land should not be transferred or dealt with. The land office will then say, oh, because you have a court suit, I'm going to adjourn this, defer this until you resolve that court suit. The same with court proceedings. If, say, for example, there is a caveat and you don't want to go through the registrar, you want to take it to court to remove, what we can then do for you is file a proceedings to remove the caveat, which is just an originating summons, no need trial. You don't need witnesses for that. So when we file a proceedings, the other party counter strategy is to file a suit. When there is a suit filed, this court that is hearing your caveat proceeding will say, oh, I can't remove it yet because there is a suit. So you go and argue it in that suit, which means then you have to go for the whole process of a bicara penuh. You have to go through the witnesses, you have to go through wrongful termination argument and so on. So the short answer to your question is no, you can't stop that process because it's a very simple borang to lodge.
Thank you Puan Shariza, thank you Puan Wai Fong. Okey, jika tiada sebarang pertanyaan lanjut, majlis ingin berjemput Haji Idris dengan diiringi oleh Puan Sapna dan Puan Silawati untuk menyerahkan sedikit cenderahati kepada Puan Shariza dan Puan Wai Fong.
Sorry.
Aziz ambil tengah-tengah. Aziz awal kat Puan Sapna. Dengan berakhirnya sesi penyerahan cenderahati tersebut, oleh demikian saya sudahi majlis pada hari ini dengan ucapan terima kasih kepada semua yang hadir dan mohon maaf sekiranya terdapat sebarang kekurangan sepanjang penganjuran klinik perundangan pada hari ini. Sekian, terima kasih. Assalamualaikum warahmatullahi wabarakatuh.